Sheriff Kyle Overmyer of Sandusky, Ohio was pretty much the shoo-in to win re-election to the post he was originally appointed to after the previous sheriff died, and a nice little raise that goes along with it in November. Although, the Republican Party hasn't decided whether they should withdraw their support just yet, the fact that he was just indicted on 43 charges, 38 of which are felonies, related to drugs and theft of cash from his and surrounding jurisdictions might put a slight dent into his campaign. Apparently, not only did he go doctor shopping to get multiple prescriptions of opiates filled, but he also drove all over the county collecting drugs people had left in various departments' drug take-back boxes, which are intended to allow for the safe disposal of expired or no longer needed prescription drugs. According to the good sheriff, he was collecting all the drugs he could get his hands on in order to promote communication between the departments. Then, just to round things off, he stole a bunch of money from the department over the course of 2 years by writing himself checks and tampered with official police records to cover up that theft. Via the news-messenger.com, the sheriff faces several felony counts of deceiving physicians and pharmacists to obtain prescription pain medication on various dates beginning April 2014 through January 2015, including 9 separate cases of seeking Percocet, 5 instances in which he sought hydrocodone pills, and 1 case in which he sought oxycodone. He was indicted on various counts of deception to obtain drugs, filing a false financial affidavit, tampering with records, and theft of drugs, Hamilton O'Brien said Tuesday night. The indictment, which was released by the Ohio Attorney General's office Tuesday night, also alleges that Overmyer falsified financial statements between January 2009 and August 2016. Several counts in the indictment include theft in office of monetary values over $1,000, but less than $7,500. The theft allegations detailed in the indictment range from November 2013 through April 2015. Last January, it was revealed the state was investigating Overmyer in connection with the collection of take-back prescription pill boxes from county police departments, also included among the 43 charges in the indictment. During this period, Overmyer is alleged to have improperly collected the boxes from April through August of 2015. Also included in the indictment were allegations that Overmyer tampered with records between November 2013 and December 2015. Overmyer is expected to appear in court Wednesday before visiting Judge Patricia Cosgrove. Ohio Attorney General Mike DeWine released a statement detailing the counts against Overmyer, including 12 counts of tampering with records, all third-degree felonies. Overmyer is alleged to have tampered with records concerning the department's furtherance of justice account. 12 counts of deception to obtain a dangerous drug, all fourth-degree felonies. Overmyer is alleged to have deceived physicians and pharmacists in order to obtain prescription pain medication, according to DeWine's release. 6 counts of theft in office, all fourth-degree felonies. The sheriff is alleged to have improperly taken medication from prescription drug disposal drop boxes. 4 fourth-degree felony counts of theft. 1 fifth-degree felony count of theft. 5 first-degree misdemeanor counts of filing false financial disclosure reports. Hamilton O'Brien, the Delaware County prosecutor, said Overmyer is still the sheriff in Sandusky County, and said she is working with Overmyer's legal counsel to have him turn himself in. The investigation that resulted in the charges is actually the second investigation launched by the Ohio Bureau of Criminal Investigations. The original investigator, Special Agent Jeff Cook, had to be removed after he told police chiefs from the department's Sheriff Overmyer had been improperly collecting the drugs from that the investigation was trivial and minor without issuing any warrants or subpoenas and without interviewing anybody from those departments in relation to the matter. The dozens of subsequent charges emerged after 2 other agents were assigned to investigate. Meanwhile, Sandusky Sheriff's Deputy Sean O'Connell is being investigated and could possibly face charges himself for acting as a whistleblower by leaking files containing the information that justified those charges to Carol Hamilton O'Brien, a special prosecutor assigned to the case.
County Court of Common Pleas, the Honorable Patricia Cosgrove presiding. You may be seated.
Be seated, folks. Thank you. Okay, we're ready for respondent. Defendant, defense would be nice. We are here today in reference to the State of Ohio versus Kyle Overmyer, case number 16CR870. The State of Ohio is represented by County Prosecutor of Delaware, Carol Hamilton O'Brien, and also Andrew King. The defendant is here present in custody, and he is represented by Attorney Ronald Maley and Attorney Jeremiah S. Ray. The purpose of today is to, first of all, arraign the defendant, set a bond, and set further dates for the progression of this case. So in terms of the arraignment, let's start there. Who would like to proceed on behalf of the defendant in reference to the arraignment? Attorney Maley?
Your Honor, we would waive reading of the indictment, waive any irregularities, estimate of service or time of service, and enter a plea not guilty to all counts.
And he did, it's my understanding, he did receive a copy of the indictment yesterday evening, is that correct?
Correct.
And did he read it, and does he understand it?
Yes.
Very well. The court will accept the plea of not guilty, entered on behalf of your client, Mr. Overmyer. The next issue the court wants to address is the issue of bond in this matter. The court will hear from prosecutor.
Thank you, Your Honor. The state would request a $250,000 bond, a cash of surety. Additionally, we would request a recognizance bond on the defendant's signature. As conditions of bond, we would ask, and it is required by law that he turn over all guns that are in his possession or that he has access to, so that would be any guns he may have through the county or that are his personal guns and are his personal residence. This would be pursuant to 2923-1383 as he is under indictment for the drug offenses. We would also ask that he not be allowed to have any contact with witnesses as listed or as known to the defendant. We have notified the defense attorneys that we will be getting them a list of witnesses. This will be a preliminary list and will probably be supplemented, but we will get that to them as soon as possible. We will also ask that the defendant not have any contact with employees in the sheriff's office during the pendency of this action. We would ask that he be required to turn in all sheriff's office property that he currently has in his possession, specifically badges, keys, any key fobs, his vehicle that is a county vehicle, his hands-free phone, the headphones, any credit cards that are the county's that he has in his possession, the county phone, and we would also ask that if he has a passport, that be required to be turned over.
In terms of electronic discovery, we did talk initially, you mentioned the issue of discovery, and the court indicated that I believe electronic discovery would be appropriate, and the court set a deadline for September 12th for the state to furnish the defendant with all discovery you plan on utilizing in this prosecution. I understand there's other information in banker boxes located in your office that you don't plan on using. However, if defense counsel wants to view that information, they are more than welcome to do so. Is that correct?
Yes, Your Honor. My office has a policy of open discovery, so every document we have will be available to the defense to view and pursuant to the court's order. We will have electronic discovery available to the defendants September 12th. If happens, we will work with the defendants to make sure, the defense counsel to make sure we get the discovery done as soon as possible.
All right, thank you, Prosecutor O'Brien. I'd like to hear from the defense regarding the request for the amount of bond in this matter.
Yes, Your Honor.
Charlie?
These are obviously serious charges. We tend to defend them, but they are serious, and we recognize the appropriateness of some bond. We feel $250,000 is high. His man has lived here his whole life. His family's here. He's already indicated in previous matters with the court that he's engaged counsel. He wants to defend this. We think $150,000, 10% would be more appropriate. The other conditions, I really don't have any comment on, Your Honor.
Yeah, how long has Mr. Overmyer been a resident of this community?
All my life.
Well, I mean, how long is that?
42 years.
42 years. How long have you lived in the same residence?
17 years.
All right, it's my understanding this investigation has been ongoing for a period of time. If Mr. Overmyer was going to leave the jurisdiction, I would suspect he would have done it by now. And considering the factors set forth in Criminal Rule 46, some bond is appropriate in this case. The court is going to set bond in the amount of $150,000, 10%, which means he has to impose $15,000. In addition to that, the court is going to impose a $50,000 personal recognizance bond. And I need to inform you, Mr. Overmyer, as you probably already know, that if you don't show up on a signature bond, that is a separate felony, and you can be charged with a separate felony for non-appearance. Do you understand?
I do.
The court also considering Criminal Rule 46, I'm going to impose the following conditions on you in terms of bond. First, you are to surrender a passport if you have one. You're to have no contact directly or indirectly with any member of the Sandusky County Sheriff's Office or any potential witness in this case. You are to forthwith, through your attorneys, turn over any county property, including access to computers, cars, telephones, passwords, anything that you have that could be utilized to access county equipment. I'm also ordering that you surrender your identification from the Sheriff's Office, any identification, your badge, so forth. Obviously you're going to be ordered here as a condition of your remaining on bond to surrender any weapons that you garnered in connection with your office. In addition, as pointed out correctly by the state of Ohio, pursuant to Ohio law, once you are indicted, even though you have been convicted of certain drug offenses, you are under a disability and cannot possess or be around weapons. So the court, again, I'm going to rely on counsel to effectuate this order, that you turn over any additional firearms that you may have in your residence to counsel, and counsel will put them somewhere for safekeeping.
Your Honor.
Go ahead.
On the weapons, any weapons that would have been issued by the Sheriff's Office would go to the Sheriff's Office. And then personal weapons, we have no objection to counsel getting those, but we would ask for some sort of list of those.
Well, I think counsel's going to have to, his counsel's going to have to talk to the sheriff. I don't know what weapons are issued as part of, or what weapons he carries as part of, or did carry as part of his duties as the sheriff. I don't have any problem with that, providing they're secured and locked up.
Your Honor,
Go ahead.
I acquired, he has no separate personal weapons. He has two sheriff-issued weapons, which he can, and they probably turn it into the sheriff's office.
Okay. Along with his identification, his badge, and his car, and telephone, and all the other property.
Right.
Thank you. Does the state, in a separate proceeding, intend on pursuing revocation of or suspension of the sheriff's duties pending the outcome of this case?
Yes, Your Honor. And that will be filed very shortly.
And that is separate and apart from this The court, I'm going to set the following dates for the progression of this case. I talked with the attorneys in chambers. I'm assuming the defendant is going to be able to post bond. If he's not able to post bond, then I would ask the attorneys to generate a conference call to the court. I'm not saying I'm going to lower it, but just generate a conference call to the court, because that would mean I have to move up the trial date. The trial date that the parties agreed on is going to be, unless he remains in jail, then I'll move it up. Didn't we say May 15th?
March 16th.
I'm sorry.
March 6th.
That was a different date. We agreed on what, March 16th at 9 o'clock?
March 6th.
March 6th at 9 o'clock for the trial. Final pretrial will be February 17th at 11 o'clock. I also want to stay on top of this case, so I did want to conduct a telephone pretrial with counsel, just to make sure that discovery is progressing and there are no issues or other problems in this case. The court discussed doing a conference call in this case. What date is good for the parties?
I think we set it for November 9th, Your Honor, the day after the election.
At noon?
November 9th at noon, the court will set a telephone status, and Prosecutor Bryan, can you initiate that phone conference to opposing counsel and the court?
Yes, Your Honor.
The court will set further deadlines regarding disclosure of witnesses and exhibits for trial. I'll put on a case management order in the future that will define further deadlines for the notification of witnesses, exhibits, eliminate or pretrial motions as well. Any other issue that either side wishes to raise at this time? Pre-mailing?
No, Your Honor.
Prosecutor O'Brien?
No, Your Honor. Thank you.
That concludes these proceedings. Thank you.
Please rise. The court is now adjourned.
Sit down. Can't see the guy. Sit down in the front, please.
Yes, he's gonna,
Sit down.
before he